Hello viewers, welcome to the subject Women and Law. Our lesson for today is Present Status of Women, Role of Law and the Constitution. The objectives of this lesson are firstly, to understand the importance of the subject Women and Law. Secondly, to trace the changes that occurred in the status and position of women in various social institutions through various ages. Thirdly, to understand the evolution of women's rights. Fourthly, to analyze the constitutional provisions protecting women in India. And lastly, to analyze the concept of gender justice in India. Now, let's start with the purpose of studying the subject Women and Law. Law is applicable to all citizens of a country, both male and female, and cannot be divided into compartments such as law relating to men and law relating to women. This is reflected in Section 13 of the General Clauses Act 1897, which states, words importing the masculine gender shall be taken to include females. Whatever law is applicable to men is also applicable to women equally. However, due to the historic and social inequities suffered by women, some laws have been enacted with focus of uplifting the dignity and status of women in society. It is not an exaggeration to state that women are disadvantaged from cradle to grave. Women around the world and in India are under the clutches of discrimination, oppression, and violence within the family, at the workplaces, and in the society. The root causes of all the evils faced by women can be traced to illiteracy, economic dependence, caste restrictions, religious prohibition, lack of educational opportunities, and apathetic and callous attitude of the society. Like men, women also play equal role in the family and national development. But her condition is not recognized by the patriarchal society. The cardinal goals of democracy, of the people, by the people, and for the people cannot be achieved if women who form half of the sky are kept out. The principal attempt in this lesson is to capture the past and understand the steps taken to mitigate the same. In the following sections, we shall make an attempt to discuss the various aspects of women's status in Indian society. In order to have a better understanding of the present social position of women, it is necessary to know the various historical, political, cultural, and economic factors molding the society. It is also critical to have a brief look at the past society because some of the norms and values affecting today have their roots in the past. We shall now look at the position of women in ancient India. From the available documentary resources, the status of women in ancient India was par excellence. There are many references to women scholars in the ancient literature. Maitreyi was a minister in the court of King Janaka, and 10 hymns to the Rig Veda are accredited to her. Gargi was another Brahmavadini who has many hymns in Rig Veda accredited to her. This shows that there may not have been barriers for women socially and educationally, and women were considered equal to men. Women, like men, received education and had access to all branches of knowledge. Women had a choice in selecting their husbands. Widows were allowed to remarry. Kautilya dealt with the problem of divorce and widow marriage and did not prescribe sati. Women had ownership rights of property. Women were not secluded from men or public life. The wife participated in all religious ceremonies along with her husband. The Buddhist and Jain traditions also honored women with great respect. But the position of women started to deteriorate in the post-Vedic period, and women were denied education, inheritance rights, property rights, and equal rights with men. Next, let's examine the status of women in medieval India. There was considerable erosion in the position of women in the post-Vedic period. The medieval period witnessed further deterioration of women's rights. Religious and educational disparity started emerging. Widow remarriages and intercaste marriages were restricted. Child marriages became the norm. Due to the Muslim invasions in the medieval era, women were burdened with many social evils such as child marriage, parda system, sati, polygamy, female infanticide, absence of property rights, and etc. The evil dowry system emerged in this period. All these resulted in gross inequality and illiteracy in women, and they were consigned to the dustbin of the society. The Bhakti movement tried to restore women's rights and could succeed in granting religious freedom to women, but there was no major change in their social or economic status. Thus, the exalted social, economic, and political status enjoyed by women in ancient days gave way to a subservient status in the medieval period. Let's now look at the status of women in British India. The British were principally concerned with propagating their regime in India. Whatever may have been the reason, the British took some baby steps in restoring women's rights in British India. The British generally applied a mix of ancient Hindu law and British law on the matters of women's inheritance, marriage, and rights of married women. The second half of the 19th century saw several social reforms for the uplifting of women due to the efforts of great leaders like Raja Ram Mohan Roy, Dayanand Saraswati, Swami Vivekananda. Various laws were passed to raise the marriageable age of girls, abolition of sati, etc. While the social reforms movements strived to uplift the social position of women, the demands of the freedom movement enabled women to enter the political arena. Some of the important laws enacted in British era addressing women's rights were the Sati Prohibition Act 1829, the Hindu Widows Remarriage Act 1856, the Married Women's Property Act 1874, the Child Marriage Restraint Act 1929. Though these laws can be termed a progression of women's rights, they were only a first step and could not improve the women's position qualitatively. With the coming into force of the Indian Constitution in 1950, a new paradigm was ushered into the social and political life of the country. The preamble to the Constitution echoes that justice, liberty, equality, fraternity is to be secured to all its citizens. Thereafter, the Constitution addresses the founding principles in the Part 3, Part 4, Part 4A, which we shall now examine in some detail now. What are the fundamental rights? Part 3 of the Indian Constitution, titled The Fundamental Rights, enlists the most basic rights of every human and has been declared by the Supreme Court of India to be a part of the basic structure. Article 14 declares unequivocally that the state shall not deny to any person equality before law or the equal protection of laws. However, the Constitution makers were alive to the fact that a mere declaration of equality would not bestow it in reality and hence made special provisions for women and weaker sections of the society. Equality is a mirage except when there is a parity between the parties. Hence, the Constitution under Article 15, Clause 3 permits the state to make special provisions for women and children. The Supreme Court has held in a number of judgments that differential treatment of people who are not similarly situated is a reasonable classification and upheld enactments empowering women. Utilizing this power, the legislatures have provided for reservation of seats for women in educational institutions, jobs in local bodies, etc. Trading in humans and their exploitation in varied forms by traffickers is one of the most despicable forms of human rights violations. Trafficking includes not just exploitation by prostitution, but also includes forced labor and slavery. Majority of the trafficking victims in India are women and female children. While the Constitution unequivocally prohibits traffic in human beings under Article 23, Clause 1 of the Constitution, the ground reality is not very encouraging. The National Human Rights Commission, in a 2002 report on human trafficking in India, acknowledged that there is no credible data on the number of people afflicted by this problem. This shows that there is official apathy on this area, just like most women's issues. Let's now examine the directive principles of state policy. Inspired by the Irish Republic, the directive principles of state policy are enshrined in Part 4 of the Constitution. While the fundamental rights are justiciable, the directive principles are not justiciable. Hence, for any infringement of a fundamental right, a writ can be sought from the constitutional courts, but by virtue of Article 37, a writ to enforce the directive principles is not available. These are the directives which no government can afford to ignore, and they are, in fact, the directives from the Constituent Assembly to the future governments to incorporate them in the decisions and policies to be formulated by them. The directives were meant to be the fundamental principles which should necessarily be made the basis of all executive and legislative actions that might be taken in future in the governance of the country. To illustrate, Article 39 lays down under Clause A that the state shall endeavour to secure a social order for the promotion of equality of men and women. Under Clause D, equal pay for equal work for men and women. And under Clause E, the health and strength of the women workers not to be abused. Article 42 states that state shall make provision for securing just and human conditions of work and for maternity relief. In furtherance of this goal and utilizing the power under Article 15, Clause 3, the legislature has brought in various enactments for improvement of women, such as the Equal Remuneration Act, the Maternity Benefit Act, etc. Let's now examine the fundamental duties enshrined in the Constitution. Article 51A was introduced by the 42nd Constitutional Amendment as Part 4A of the Constitution, outlining the fundamental duties. Clause E of Article 51A casts a duty on every citizen of India to renounce practices derogatory to the dignity of women, the duty to promote harmony and the spirit of common brotherhood amongst all the people of India. Many laws have been passed by the Union government and state governments which punish practices derogatory to the dignity of women. The passing of the Commission of Sati Prevention Act 1987 emphasizes the importance of the duty. The Prohibition of Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013, the Equal Remuneration Act 1976, the Maternity Benefit Act 1961, the Dowry Prohibition Act 1961, and the Immoral Traffic Prevention Act 1956 are some of the enactments which can owe their existence to the above fundamental duty. Let's now examine the importance of Uniform Civil Code to women. A uniform civil code administers the same set of secular civil laws to govern all people irrespective of their religion, caste or tribe. The Article 44 of the Constitution recommends the state shall endeavour to secure for citizens a uniform civil code throughout the territory of India. The common areas to be covered by a civil code include laws relating to succession, marriage, divorce, adoption. This supersedes the right of citizens to be governed under different personal laws based on their religion or caste or tribe. The Uniform Civil Code will give women more rights, will break down the customary practices harmful to women, and give women individual identity as independent citizens of India. Such a code will not take away the right to perform religious ceremonies and rituals, but will give equal property rights, protect her from polygamy and arbitrary divorce, grant her the right to adopt and the right to inheritance. Hence, the Uniform Civil Code is now also a women's rights issue. Though the civil society and legislatures have been slow to fulfill this constitutional mandate, the Indian judiciary has taken note of the injustice done to women in the matters of many personal laws. It has been voicing its concern through a number of judgments indicating the necessity to have uniformity in personal matters of citizens. Justice Kuldeep Singh, in his landmark judgment in Sarala Mudgal versus Union of India, rightly observed that Article 44 is based on the concept that there is no necessary connection between religion and personal laws. No gender justice could be rendered unless we have a uniform civil code containing the best provisions from all the religions. Unless the women, irrespective of their religion, have been conferred equal rights on par with men in personal matters, the constitutional mandate of right to equality of status and opportunity cannot be fully implemented. The Indian Republic was wedded to the ideals of equality with special attention to uplifting of women in independent India. The commitment of the Indian Republic to women's rights is reflected in the various 5-year plans that devoted special attention to women's issues, and special emphasis was laid from the 5th 5-year plan onwards to women's welfare and development programs. The National Commission for Women was constituted under the National Commission for Women Act 1990. Its main objectives are undertaking research, look into the cases of violations of women's rights, work with appropriate authorities on violations of women's rights. Various states such as Kerala have passed similar laws to constitute state women's commissions to look into the issues faced by women in their states and improve the social status of women. To increase the participation of women in governance, the 73rd and 74th constitutional amendments brought in 1993 provided for reservation of seats in local bodies for women under Articles 243D and 243T of the Constitution. The pending attempt to reserve 1/3 of the seats in the state legislatures and the parliament for many years shows that there is a long way to go before full parity can be achieved in women's equality. In 1991, a 10-year national plan of action for the girl child was launched by the Government of India to ensure survival, protection and development of the girl child. National Policy for the Empowerment of Women was rolled out in the year 2001 with a goal to bring about the advancement, development and empowerment of women. What do we mean by gender justice? Let's examine in some detail. Gender is a common term, whereas gender discrimination is meant only for women because only females are the victims of gender discrimination. Gender justice refers to equality between the sexes in matters of social, economic, political, environmental, cultural and educational factors. The framers of the Constitution bestowed sufficient thought on the position of women in Indian society and provided special protection to women in Articles 15, Clause 3, 16, 19, 39 and 42. The Constitution not only grants equality to women but also empowers the state to adopt measures of positive discrimination in favor of women. India has also ratified various international conventions and human rights instruments committing to secure the equal rights of women, like the Convention on the Elimination of All Forms of Discrimination Against Women 1979, which is popularly known as CEDAW. International Covenant on Civil and Political Rights 1966 is popularly known as ICCPR. Several laws, policies, institutional reforms have been enacted by the legislatures right from the colonial period to carry out the gender equality mission for the development of women, such as abolition of sati in 1829, widow remarriage was made legal in 1856, female infanticide was banned in 1870, the Child Marriage Restraint Act was passed in 1929, women get special rights to property in 1937, the Dowry Prohibition Act was passed in 1961, and the Commission of Sati Prevention Act was passed in 1987. Apart from these laws, many industrial laws contain special provisions for women, and there are some women-centric laws such as the Maternity Benefit Act 1961, the Equal Remuneration Act 1976. Many other penal provisions to provide protection and security to women at home or at workplace have been enacted, such as the Nirbhaya Act 2013, Domestic Violence Act 2005, and the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. The establishment of the National and State Human Rights Commissions and the National and the State Commission for Women gave good attention to gender issues. In a number of cases, the Supreme Court has upheld the right of women in dignity and attempted to improve the status of women. A few are Air India versus Nargesh Mirza, 1981, Vishaka and others versus State of Rajasthan in 1997, Apparel Export Promotion Council versus A.K. Chopra in 1999, and Madhu Kishwar versus State of Bihar in 1996. In spite of having many enactments dealing with women and courts rendering many judgments for protecting women, the condition of millions of women has not improved significantly, and they still face various types of atrocities in their daily life. The constitutional goal of gender justice can be achieved to a great extent when the Uniform Civil Code is adopted in the country. From the current discussion, we can conclude that there has been some progress in women's rights. However, it is a bitter truth that even after 65 years of Indian Constitution, women still face many social evils and handicaps in the patriarchal Indian society. Empowering women with the help of laws, education and employment has brought millions out of the clutches of gender discrimination and attempted to establish women as an equal to men. If gender discrimination is eliminated, women can deliver with their full potential, skill and knowledge, leading to the fuller development of India. In the following lessons, we shall study how Indian women have been empowered by various protective measures in the fields of family law, employment law, procedural laws, international law, etc. The forthcoming lessons give us an insight into the contribution made by the law as a means of social change. I wish to close with the famous inspirational poem by Robert Frost, which incidentally was quoted by Pandit Nehru on the eve of Indian independence on midnight of August 14, 1947. The woods are lovely, dark and deep, but I have promises to keep, and miles to go before I sleep, and miles to go before I sleep. Thank you and hope you enjoyed this session, and see you in the next class.